Next, we will take up Representative Blaise Juicy's bill, House Bill 5650. Representative Juicy.
Thank you, Madam Chairman, members of the committee. House Bill 5650 would ensure that no person who's under the age of 18 could be sentenced to life imprisonment without parole for any offense occurred prior to their 18th birthday. There's a national movement to work on this issue as an example of cruel and unusual punishment, and there are some people here to testify. I look forward to hearing their testimony, and thank you for your consideration.
Thank you, Representative. I'm so sorry, I cannot read the handwriting for this first one. Malkovich? Malkovich, he's not here. He is...
Marcus Mitchell.
What is
No,
it?
Marcus.
Okay, it's like scribbled here, so. Okay, well, he's not here, but he signed up in Pro. He wants this bill. John Prince, is John here?
Left.
John left, and he didn't check off pro or con. Stephen Brown from the ACLU.
Thank you, Madam Chair, members of the committee. The ACLU is here to express our strong support for this legislation. There is a nationwide effort to pass laws like this. It's the culmination of a series of Supreme Court decisions that have recognized juveniles are different when it comes to crime and when it comes to punishing them. There have been 3 U.S. Supreme Court decisions in the last 7 or 8 years limiting penalties against juveniles, including life without parole. The last decision of the Supreme Court was that it was unconstitutional to have mandatory life without parole sentences for juveniles. This is the next logical step this legislation is, and we hope it will have the committee's support. I won't go into all the details about why juveniles should be treated differently. I think there are lots of obvious reasons, and perhaps other speakers here will mention it. I do just want to mention 2 things about the incredibly broad range of support for legislation like this across the country. Among the organizations that are supporting this effort are the American Bar Association, the American Correctional Association, the American Probation and Parole Association, the American Psychological Association, we have national children's rights groups, including the PTA, the U.S. Catholic Conference of Bishops. There really is an incredibly broad range of organizations that recognize it simply is not proper to say that somebody who commits a crime, however heinous it may be, before the age of 18 is irredeemable and simply should just be given up on for the rest of their life. The final point I'll make is that, unlike Rhode Island, unfortunately, there are attorneys general in other states who have been expressing support for this legislation. Just in the past couple of months, the Attorney General of Maryland, the Attorney General in Vermont expressed support for pending legislation in those states. I know last year when Hawaii passed a ban on life imprisonment without parole for juveniles, the Attorney General there also supported it. In light of the broad recognition of what this bill is trying to do, we hope this committee will support it as well. I'll be glad to answer any questions.
Any questions, Mr. Brown? Representative Brady.
So I don't know much about sentencing, but would this bill ban a 99-year sentence?
It would not. It would specifically only ban life without parole. I think that's an issue that should be considered at some point, but I think this is an important step.
Great question. Thank you. Any more questions? Thank you, Mr. Brown. Mike DeLario?
Thank you, Madam Chair, committee members. This is a relatively simple piece of legislation. When you consider it, the question I think that is being posed is, should Rhode Island's ultimate sanction life without parole? We don't have a death penalty in Rhode Island. Should our ultimate sanction be available in cases involving juveniles? And I would submit to you that the answer is no. There are many good reasons for this. Our nation's courts, as Mr. Brown has pointed out, have begun to recognize the nature of the juvenile brain is not yet fully developed, and they have actually used this in a series of cases as Mr. Brown said, to limit certain types of sentences for juveniles. In our own state, Justice Flaherty, in a case by the name of Page versus State, writing in dissent, said this about juvenile life without parole. The defendant in this case is the product of a dysfunctional family. Both of his parents were drug addicted, and his father and grandfather were HIV positive, likely as a result of drug use. His father eventually died of AIDS. Of course, none of this excuses the brutality of his actions, for which he deserved a life sentence. But in my view, when one considers the obstacles with which he has been confronted, coupled with his age, the chance for rehabilitation exists, then Mr. Page should not be consigned to the rubbish heap of life. He went on to say that Mr. Page had in fact passed the threshold of majority, if just barely, when he murdered Mr. Gardner. But while there must be some arbitrary bright line demarcation between youth and adulthood, there is no question that few, if any, young people are imbued with the attributes of adulthood as soon as their 18th birthday. I think what Judge Flaherty is saying in that dissent is that we have things in place, we have experts in place to pass upon an individual's rehabilitation and reentry possibilities. The Parole Board, the Department of Corrections, and those rehabilitative and reentry efforts should be judged on a case-by-case basis, not painted with the broad brush as our current law does. The legislation does not say that severe punishment should not be handed out in appropriate cases. Individuals like Mr. Page, for example, should be and are punished for a long, long period of time. All this legislation is saying is that Rhode Island's ultimate sanction should not be available in the cases of individuals who committed their offenses as juveniles. We have to answer any questions you might have.
Any questions? Thank you, Michael. Joey? Okay.
Thank you, Madam Vice Chairwoman. We are opposed to this bill. I'd like to talk a little bit about life without parole. Our only mandatory life without parole sentence is murder, and it can only be achieved in 7 enumerated circumstances that have been put out before this assembly. One is felony murder. One is a murder created in a matter creating great risk of death, a bombing, something of that nature. Murder for hire, torture or aggravated battery, killing of a law enforcement officer and its official duties, murdering someone who was confined at the ACI while they are confined, and a murder during the sale of drugs. Murder without the life without parole is the most severe sentence that our assembly handles, and it is very rarely used. For life without parole to even be considered by the court, the Attorney General has to put in a petition within 20 days of the person's original arraignment. So we have to know we're pursuing that at least a year out from a trial, the way our pre-trial sessions are going right now. We have 31 people currently sentenced to life without parole in the state. That number is of December 31st of 2014, to show the rarity that this is used. To speak about Miller versus Alabama, which is the case that Mr. Brown was talking about, Miller stood for mandatory life without parole in a case where there was no hearing about the life without parole section. We have an entire chapter of general laws detailing how the judiciary must treat these cases. There must be the notice by the Attorney General. If there's a trial, if there's a plea, after the finding of guilty or the plea of guilty, there has to be an additional hearing in front of the trial judge and jury or the trial justice itself that weighs the aggravating and mitigating circumstances to that defendant. That's exactly what Miller versus Alabama was about. Justice Kagan, who wrote that decision, emphasized that judges must be able to consider the characteristics of juvenile defendants in order to issue a fair sentence. That's exactly what our law set out. That's exactly what this General Assembly set out. We do have the Miller statutory scheme. I would just say a couple more things before leaving you on this matter. I think everyone in this room, certainly everyone at the Attorney General's office, can understand why we would not want to sentence a juvenile under the age of 18 to life without parole. In those circumstances, there would have to be a discretionary or mandatory waiver hearing, bringing that person out of the family court into the adult court. Then there would have to be the petition with life without parole. It would have to be extraordinary. And that's why we have laws like this, because sometimes extraordinary things happen. People like Craig Price happens, that brings the Assembly back here writing waiver laws because we don't have the statutory structure to deal with it. Or Michael Woodmansey, who brings us back to talk about why we're giving good time to first-degree murderers. This section is so rarely used, if ever, for juveniles. It needs to be there and has the statutory and constitutional protections in place for if that worst-case scenario happens, it will be here. I'm available for any questions.
Any questions? Representative Valier?
Just quick, Grace, you done Florida now?
I believe so. He's on I believe he's being held on a contempt charge for probation. I believe that's his last step. Yes, but he's in Florida. Is my understanding. I don't know things like that, but due to his weight.
Thank you. Any more questions? Thank you, Joe.
Thank you.
We have Michael Signano from the Rhode Island Tea Party is not here, but he brings testimony in opposition. Todd Sando, the Rhode Island Tea Party, brings testimony in opposition. Randall Rose.
Thank you. I want to emphasize one thing about this bill. This bill does not ban life sentences. What it says is that for life sentences, that for juveniles sentenced to life, there must be the possibility of parole. Now, I know it's been mentioned before that there have been a series of Supreme Court decisions that have progressively limited how severe these sentences can be for juveniles. And that series of decisions does not only include Miller versus Alabama, which was about mandatory, which was saying that juveniles can't have mandatory life without parole. It also includes earlier decisions that said that juveniles can't be sentenced to death. And I believe there has been a continuing trend in that direction. The Supreme Court, as is marked, does tend to issue one decision that will chip away at things, and then another decision that chips away a little more. But it's clear that the direction the Supreme Court has been moving in is to progressively reduce the severity of sentences for juveniles. And it has not been, the Supreme Court has not been simply concerned with judges' discretion, although that was the rationale appealed to in Miller versus Alabama. I think there's a reason why the Supreme Court has been doing this consistently and why the rest of society has been largely comfortable with it. And that is, we as a society believe that there are some very heinous crimes that there are some people who are psychopathic, who are severely disturbed, who really, for our protection, should never be allowed back into society. And that's why a lot of people support the death penalty. It's why even people who don't support the death penalty generally do support life without parole, because we believe these people never get better, that it is never safe to allow them the option to come back to society. The reason why we no longer want to do that, why we no longer want to do the death penalty for juveniles, for instance, is because we believe that juveniles can be rehabilitated. That's the reason why people have been reconsidering the death penalty for juveniles, because we believe that juveniles, no matter how bad the act they did when they were very young, can be rehabilitated when they're much older. And we don't want to totally foreclose that possibility. And if that's the reasoning for a death sentence, it should be the same reasoning for life sentences as well. There should be, so the Miller versus Alabama case already established that there should be some possibility of parole for juveniles who commit even the most heinous crimes. They shouldn't be unconditionally thrown into jail for the rest of their lives. The question is, whose discretion should it be? Who should get to decide when a juvenile, somebody who committed crimes as a juvenile can be rehabilitated, when it's safe to let this person out, when they've moved on and they're no longer the same person. Miller versus Alabama decided it can't be the legislature that decides that unconditionally. But that still leaves open the question. Should it be the judge at the time of sentencing, at this time of the original trial, who looks far into the future and says that this child can never grow up to be a rehabilitated person? Or should it be the parole board who actually do have some expertise in focusing on who can be rehabilitated, who's safe? That's the only thing they deal with, unlike judges. And they get to see the person as this person is when they're older. It seems more reasonable to me to have the parole board be the ones making the decision, because they're the only ones who get the chance to make that decision based on actually looking at how this individual is as they've grown up, as they're in their 50s or 60s or whatever it may be. And I know that some people say there are some crimes that are so heinous that this person must be unconditionally removed from society. The problem is that society changes in what it considers those heinous crimes to be. There are some periods when there's an overreaction by society and society starts endorsing very tough sentences, and then a few decades later society realizes those sentences were too tough. So, for instance, you can be sentenced to life without parole for murders committed during drug deals, even though there are some children who get caught up in the drug trade, who are not beyond redemption, but who do commit killings, just like a few of them do commit other kinds of killings. And they do have a chance to transcend that when they have a chance to think over their life and to see the world from a more mature vantage point. So although things may seem very heinous at the time, it's better to allow some more perspective, and that's what this bill does. It allows for the people who have the most insight to whether somebody can be redeemed to look into that. Thank you.
Thank you. Any questions for Mr. Rose? Thank you, sir. Adele? How do you say your last name, please?
Born, yeah, as in bridge,
All right.
as in born identity.
Thank you.
I don't have anything much to add to Mr. Brown's testimony or to Mr. Rose's testimony, and I certainly don't have the understanding or knowledge in order to do that. I'm just here as a substitute for Martha Yeager, who is the member for support committee for the American Defense Service Committee, Southern New England branch. And she wrote testimony that has been distributed. I also said I would come and give some hours here to listen to you all, because like many of you whose background are in law and various kinds of public service and social work, or in teaching, or in medicine, or in the ministry, you know probably more felons than I do. But I've known 5 very well who were under the age of 18. One in particular has just finally received parole at the age of 35 after getting his associate's degree, teaching other inmates in the penitentiary where he is high school English. He has become an electrician, he's become a mechanic, and an accountant. He has finally had an amazing, parole board has finally accepted his that he's changed enough, and he first started his 17 years old, no, he's thinking 16 years old. He had been a victim of extreme abuse and neglect. He was more or less on the streets from the time he was 6 years old. He was supposed to be in special services in school. I was in special education for some time. Didn't quite work for him because there wasn't enough backup in lots of ways. Anyway, this gentleman, Kendrick whose last name I can't give you. But the people who took care of him were the drug lords in the neighborhood, and the gang was his family, and he was asked to shoot up with an AK-47 a neighborhood building where an opposite gang lived, gang member lived. So that began a very long career. Well, he finally is out. He has spent his life getting out, being able to come out. And the point is that the prison in this case worked for him. This was in Pennsylvania. It worked for him, gave him the stability he had never had before, gave him the services he had never had before. And I think he's going to really make it. Looks like he has a cousin who has offered him a job, and I think it's a distant cousin. I think it really will work for him. So that's why I'm here, and that's why I'm so glad this bill is before you all, and I'm very, very happy about it, and I hope you all pass it. Thank you very much.
Thank you very much. Any questions? Thank you very much.
Yeah.
Vin Vincent, please. Oh, it's Jim Vincent, I'm sorry.
Vice Chair. Jim Vincent, President of the NAACP Province Branch, and I am here to strongly support the bill. And I don't want to repeat what Mr. Brown and Mr. Rose said. The one thing I want to bring up is that we're concerned about the potential for discrimination as far as the application. In other states, there's a disproportionate amount of kids that are black that get it, that have murdered white victims, while 23% of juvenile arrests for murder involving African American suspected of killing a white person. 42.4% of the white rock roll sentences are for African Americans convicted of this crime, almost twice as much. White juvenile offenders with African American victims are only half as likely to receive their life without parole sentence as their proportion of arrests for killing an African American. So we're concerned about the application, and that like anything else, there's been a disproportionate amount of African Americans that seem to get the life without parole from the right victims as opposed to the other way around. So we are strongly in favor of the bill, and thank you, Committee.
Thank you. Any questions for Mr. Vincent? Thank you, sir.